Okay, so we're gonna go ahead and get started. I just wanted to thank everyone for joining today. My name is Emily Kubera. I'm the Development and Communications Manager here at the Treatment Advocacy Center. Before we get started, I just wanted to let everybody know that this is the first webinar in a 4-part series. Our next webinar will be a town hall with Acting Executive Director Lisa Daly on March 17th at 12 o'clock Eastern Standard Time, followed by Advocacy 101, the do's and don'ts of lobbying on April 21st with Legislative and Policy Counsel Michael Gray. This will also be at 12 p.m. Eastern Standard Time. And the last one will be Advanced Advocacy Communications Tools, how to write op-eds and press releases to get your message out with our Director of Communications, Jeffrey Mulata. This will be on May 14th at 12 p.m. Eastern Standard Time as well. And we will release registration for those webinars as we get closer to those dates. If you have any questions for Michael during the Q&A portion or throughout the presentation, you can just chat them to the panelists. You can just chat them to the panelists, and when we hit the Q&A portion, Michael will answer as many questions as we have, as he can in the time allotted. We have until 1 o'clock, so feel free to please send us your questions during that time. So I will pass it over to Michael and let's get started.
Thanks, Emily, and thank all of you who have joined us today. As Emily mentioned, I'm the Legislative and Policy Counsel, or one of them, at the Treatment Advocacy Center. And we're going to talk about the HIPAA Privacy Rule, some pending changes, how it impacts you and your families, and one very important thing that you can do to get involved and be a part of improving the HIPAA Privacy Rule. With that, I'm going to share my screen, show you some slides. When I say show you some slides, these are minimal slides just to make sure that I stay on track. So first, we'll talk about HIPAA and the Privacy Rule, what exactly they are, and then the impact on families like many of yours who have joined today. I'm willing to bet that if you're on this Zoom right now, either you or someone you know has had a god-awful family situation because you were unable to properly communicate with your healthcare providers. Talk about the proposed changes that are coming up, some changes that should improve the privacy rule. They don't go far enough, but they do some good things, and the rulemaking process itself. And the comment period, and that's the part where you can get involved. Let's zoom out a little bit and step back in time. I am incapable of discussing or understanding public policy and the law without knowing the historical context. I know for some of you, history is interesting in and of itself, but even if you're not one of those people, please understand that it's the only way we can fully wrap our heads around the good and bad parts of the current law and policy that govern everything to do with severe mental illness today. So what is HIPAA? Where did it come from? To healthcare providers, HIPAA is a big, scary acronym that first graduate schools and professional schools, and then their employers, hospitals and the like, use to scare them out of ever sharing any information about anyone or anything. But to family members, to people that have a loved one with severe mental illness, HIPAA is a barrier. It's a barrier to treatment that keeps you from getting your loved ones the treatment that they need. So why does it exist? Go back in time to the early to mid 1990s. The United States has a new president, Bill Clinton, and in 1994 elects a new Congress. This is the time of Congressman Newt Gingrich and Congressman Army's contract for America that drew largely on political rhetoric from President Reagan in the mid 80s. And 9 years later, they used a lot of that rhetoric to successfully take the US House and Senate. Why does all that matter? Well, because you had a Democrat president, you had a highly partisan Republican Congress, and anything that's going to pass into law has to be bipartisan. And HIPAA grew out of a concern for the inability of people to move their insurance coverage between jobs, and the inefficiency and inequity of insurance coverage and how it was done in the United States at that time. So that's kind of how it started, but it grew to be a complete overhaul for how information is shared and stored and used by healthcare providers.
Hey, Michael, sorry to interrupt really quick. Your slides aren't up if you're supposed to be sharing them right now?
They are indeed. Oh, okay.
Sorry to interrupt you in the middle.
No, sorry about that.
Great, no worries.
Let's see what we can do.
There we go.
Now we're good. Okay. So the good news is you haven't missed very much. Intro slide, outline. I'm still the outline talking about HIPAA and the Privacy Rule and how they came to be. So before I drill too much on the history, I want to tell you why I'm saying all this. It's because this act that was then known as the Kennedy-Castlebaum Act, Senator Ted Kennedy of Massachusetts, Senator Nancy Castlebaum of Kansas, that's a Democrat, highly partisan Democrat and a highly partisan Republican at the time, who worked together to pass this bill, which had what we would now see to be shocking bipartisan support. But that's how you had to pass legislation back then. There was also that context I mentioned of the so-called contract with America by the particularly congressional Republicans. And there was a larger picture there where they talked about decreasing barriers for business activity in the United States. And this sort of played into that by allowing employers allowing employees to move their insurance policies around. But really, this was a policy move. This was something to do with making sure that people's information was not overshared, because you're just speaking generally, your medical information belongs to you, and it should only belong to you. Generally, of course, there are major exceptions when we need to have other people's information in order to share, to save their lives. And so, Title I of HIPAA has that insurance stuff in it. Doesn't pertain to us today, but it's worth knowing because it's why HIPAA exists. And Title II, that has the rules about privacy of your healthcare information, security of that information, and the enforcement provisions, such as they are, that the government can use to keep your information private. And if you're a nerd like me and you want to read more about that, I've got the citation to the statute down there. If you want to read that massive piece of legislation, by all means. So HIPAA comes about to modernize the flow of health information in an age where Congress was concerned about the growing rate of technology and the fact that doctors were not just keeping paper records, but were soon about to be keeping electronic records. Okay, but what did it really do? What it really did was give the federal Department of Health and Human Services the ability to make regulations, a type of law that will, in theory, protect your health information and give you that individual right of your information. We all know that's a problem when it comes to severe mental illness, and talk more about that later. But this is an overview. This is a very basic overview here of the timeline. Do not commit these dates to memory because it's loose. I mean, you see, I had to give a 3-year range for one of these. But HIPAA comes to be, and HIPAA says, Department of Health and Human Services, you shall create a rule that regulates the privacy of healthcare information. And of course, being a federal agency, they get right on that and do it right away, right? No, wrong, of course not. It took them, depending on how you define it, 7 years to get that rolling. It's a complicated process and a complicated rule, the privacy rule. There were some amendments to it, acronym high tech, just it was an update, and especially to the enforcement provisions of the privacy rule. omnibus rule summarized all that and tried to put some of those changes in the privacy rule itself into plain English. And then a piece of legislation with which many of you are familiar. There's 21st Century Cures Act. That's the last major piece of legislation signed by President Obama, bipartisan legislation. It took forever for advocates like several of you I know on this call to get that bill through Congress and onto the president's desk. It had a lot of provisions related to mental health and particularly severe mental illness. But it also instructed the Department of Health and Human Services, or HHS, to provide some guidance to clarify some of the problems with the HIPAA Privacy Rule. What is the Privacy Rule? In theory, it's simple. It just bans the disclosure of health information by certain entities, what HIPAA calls, or what the HHS calls covered entities. Again, in theory, this is simple. In practice, it is not. Protected health information is exactly what it sounds like. It's any information related to the course of treatment, healthcare, that could ever be collected, needed, or used by anyone in the course of treating an individual. That's PHI, that's protected health information. Simple enough. What is a covered entity? Who are these entities that cannot share PHI, that cannot disclose it? Health plans, healthcare clearinghouses, healthcare providers. Very quickly, I'll tell you, the one of these that is not clear on its face is the clearinghouse. What is a clearinghouse? Well, it's anyone that a health plan or a health provider might use to exchange information, disseminate information, or any organization that's not a plan or provider that may have your personal healthcare information. Can a health plan, be it a private insurer or be it a government payer like Medicare or Medicaid, can they never disclose information? Can a healthcare provider, be it an emergency room physician, a psychologist, or a registered nurse, can any of these entities, can they never disclose protected health information? No. As is the case with most regulations, there's a rule that says this is the way it is, and then there are all these exceptions. Okay. What are the exceptions? This is where it hits close to home. This is where it hits close to home for the families of people with severe mental illness, because the two exceptions that most of us meaning advocates for better and more effective mental illness treatment laws, the two areas where most of us want to see improvement are situations where currently the privacy rule says a clinician, a healthcare provider, can share someone's information with someone else if, in their professional judgment, and those are the words, an exercise of professional judgment, it is in the best interest of the patient, or to prevent a serious or imminent, that's very important, serious or imminent risk of harm. It says public safety and harm, but it means risk of harm to self or others. That's the current law. That would be problematic in and of itself, because that's a very high bar for a healthcare provider to know they are breaking the law if their disclosures of information don't meet one of those two standards. How does it impact the folks that we serve. By the way, I mean the Treatment Advocacy Center. How does it impact the people that we spend our days trying to help, individuals and families impacted by severe mental illness? And that is most often and most tragically the situations where there is an individual with severe mental illness who is in crisis. And as you all know, when an individual is in crisis, that means the family is in crisis. Caregivers, loved ones, close friends, whoever cares about that person and is trying to be a part of their treatment process in order to overcome the crisis, to move on and get to more long-term treatment plan. Caregivers, the family members, they must be able to effectively communicate with the providers. Of everything that I'm going to say on here today, that's the one thing that I bet you all already know. A lot of you know all of this. Most of you know some of these things in this presentation, but that's the thing that I bet you all know, is that there must be effective two-way communication if you're going to have effective treatment for someone with SMI who is currently in crisis. It's actually true when they're not in crisis too, but when they're in crisis, that is an emergency. And that is a time that not only the sharing of information, but the timeliness of it are critical. It's life and death. It's certainly going to impact quality of life. And it often impacts continuity of life itself for the patient. Many providers, not just mental health providers, but many providers across the spectrum misunderstand the privacy rule. The people that do tend to be overly cautious. They tend to be overly cautious. And the thing is, people like me, advocates for wholesale reform of the privacy rule, tend to be a little too harsh on those providers, the providers who misunderstand the privacy rule, misunderstand HIPAA generally, and who use HIPAA, that scary acronym they learned in school, to scare themselves away from being able to communicate, even when they know they probably should communicate better with families. They're scared because of HIPAA and the privacy rule. And I tend to be a little overly harsh on them, but because they do have some liability under HIPAA. There is no cause of action. I know there's a few attorneys on this call, so you know, in cause of action, that's a reason to sue someone. There is no cause of action for an individual whose information has been shared in violation of the privacy rule, but providers can still be sued under state law. This presentation today is not really about state law, but always remember that any major federal law has numerous ways it ties into state laws. And the privacy rule sets the minimum. It sets the minimum standard for restrictions on sharing healthcare information. States can pass stricter laws, and many of them have. There are many of you listening to this right now who maybe a provider has told you that they cannot disclose information because of HIPAA. They may or may not be right, but they may also be mistakenly referring to state law. Depends on your state. They can be sued for negligence, using HIPAA as one of the underpinnings of the negligence. So providers are scared, but they have some reason to be scared. But if they follow current law, they can still disclose information to families. And there's one thing, perhaps the most important thing, that I'm going to touch on a little bit later in the presentation again, but nothing in the privacy rule keeps families from giving information to providers. That's another roadblock that we've heard from so many. We at the Treatment Advocacy Center have heard from so many families that if they go to give information to someone, to a provider, providers, oh, HIPAA says you can't do that. Well, that's not true. But in that emergency, the fact that the provider misunderstands the law does not help you very much, does it? And that's why we're talking today about advocacy and how you can get involved. Okay. Now, let's go back a little bit. How do we get to this point? I told you Congress passes a statute, and then Department of Health and Human Services, or specifically that department's department called the Office of Civil Rights, or OCR, they promulgate a regulation, which is the Privacy Rule. How are laws made? And I mean that. A lot of smart people on this call. I'm not patronizing. I'm seriously asking you, how are laws made? And think about it for a moment. Legislative branch makes legislation. The president, executive branch enforces legislation. Judicial branch keeps them honest. That's the way it's supposed to work, according to the Constitution. Sometimes it works that way. That's the way it's supposed to work. And notice I said legislation and not laws, because there are many different types of laws. One such type of law is an administrative regulation. Congress has delegated that authority, their authority, to an executive agency. And those administrative regulations are where the rubber meets the road. They're the reason why you follow the news, or maybe you're involved in advocating for a major piece of legislation like HIPAA or 21st Century Cures Act. And then you don't really hear much more about it unless you're really involved in advocacy. You don't hear much more about those laws, those statutes. Why is that? Well, it's because they've been delegated, handed off to agencies like Health and Human Services, and they delegated to places like the Office of Civil Rights. The Office of Civil Rights within HHS, they created the privacy rule, they administer the privacy rule, and they have the authority and the power to change it. So let's go stay on that for just a moment, because I want to tell you that it was 2.5, almost 3 years ago now, OCR asked for comments on how they could improve the privacy rule. And that's an important part of this process. They made a public statement asking for comments on feedback on the privacy rule and problems that it has, particularly as relates to substance use disorder and severe mental illness. And they got some feedback. And what we're talking about today are the results of that feedback, culminating in OCR asking us, the public, for final comments on what they propose to do. Now, the reason that's important is that there is a narrow scope to this, to these proposed changes. This is not a request from the federal government asking us what all should be changed about HIPAA. They pretty much did that 3 years ago. Now they've given us some ideas. They say, well, what if we change these things? Would that be okay? And they're asking for comments again. This is the final step in the process for us, for the public. We post comments by March 22nd. More on that in a minute. Post comments by March 22nd, and then OCR takes them, and if they do their jobs, they will take our comments into consideration and promulgate a new rule, changes to the rule that will then be the law when it comes to sharing protected health information. So, what are these proposed changes? What are these proposed changes? If anyone wants to reach out to me, I can send you, although it's available for everyone publicly, but I can send you the link to the actual proposed changes document. It's very long. It's 90 something pages of fine print, but there's one section of those that pertain to us. And they're while we're here talking about this today. And they really could have an impact if those changes go through and they are followed by healthcare providers. They could have a huge impact on patient care for your loved ones with severe mental illness. Number one, I mentioned earlier that provider can share information, meaning, okay, let's hypothetical, but it happens every day, where there is an adult, a young adult with schizophrenia who is in crisis. They're admitted to a hospital. The families find out. Parents go to the hospital. They want to have that exchange, that free flow of information, that two-way communication, not free flow, but two-way communication with the docs and the other folks who were trying to treat their child with schizophrenia. The doctor can have that two-way conversation and give them information. The hospital can give them that information and have that flow of information. If it's an exercise of a doctor's professional judgment. Well, what on earth does that mean? The problem with this part of the privacy rule, as it's written right now, is that it's too vague. What on earth does it mean, exercise of professional judgment? You could ask 100 doctors that question and get 100 different answers. What OCR is proposing instead, and what they want public feedback on, is replacing that professional judgment standard with a standard that would allow doctors to come for to exchange information if the doctor has a good faith belief, the provider has a good faith belief that is in the best interest of the patient. That's a much lower standard. I'm not saying that language is perfect. I'm saying it's a lower standard and it's clearer. It is clearer than the current one of professional judgment. So that's a good thing. It could be better, but we at the Treatment Advocacy Center certainly support that change, and we hope you do too. It's something that we've been advocating for years. Is some clearer language for that part of the privacy rule. Second thing is replacing that standard I mentioned earlier of a serious and imminent threat of harm with a serious and reasonably foreseeable threat of harm. That's a little more complicated, but if you think about it for a minute, or if you've been in this situation, if you've been that family that I described, then you know why this could be a big deal. Because the word imminent in all its different forms in the English language is one of the greatest barriers to effective treatment for severe mental illness in the United States today. Imminent means what you think it means. That if we don't intervene, it's going to something bad's going to happen right now. If we don't disclose PHI, something bad's going to happen right now. A family would argue something bad is happening. My loved one is in crisis. And we need to share information so you can properly treat them. A provider might argue, I do argue back, that yeah, but it's not a serious and imminent threat. That's not vague like the first one, but it is problematic. So instead, OCR is proposing language that says serious and reasonably foreseeable. Can the provider reasonably foresee that if they do not disclose information and have that two-way communication with the family, then something bad will happen? None of this is perfect. Both of these things are much better. Okay. I keep saying that OCR, federal government, they want comments from us, the public. How do we go about doing that? We're going to share with you in the chat for this Zoom the actual link to where you can do that. Yeah, it's on federalregister.gov, but that's navigating that website takes more time than most of you probably have on your hands. So we can send you a direct link, so you don't have to go searching for it. You can find that link and enter comments. It's just entering comments for a proposed rule change like this is a pretty simple process. Now, getting your comments in line, figuring out what you want to say, that may not be simple. But entering comments, that's simple. Let me tell you about some very basic things to keep in mind when you're crafting your comments, these written comments. Be clear. Know what you're trying to say. Some of you have extraordinarily compelling, often tragic, sometimes positive, but often tragic stories about how HIPAA cost lives or could have cost someone's life. That's important. That can certainly be part of your comments, but it's important to remember what you're asking them to do. If you're saying, hey, we love these proposed changes, please enact them. Or if you're saying these changes could be better, here's how you could improve them. Remember your goal. What are you trying to communicate with this federal agency? Be clear, ask for something. Always have an ask. A lot of you have done legislative advocacy. Same idea applies. Know what you're asking them to do before you start talking, or in this case, before you start writing, and submit your comments, because someone at OCR is going to read your comment. Be concise, be concise. This is a problem for me sometimes, if you can't tell. I have a stopwatch to make sure I didn't spend too much time talking about the political context of mid-1990s America. I can ramble sometimes. Nothing wrong with that, unless you're trying to communicate a point to a policymaker, and then you should be concise. Stay relevant. Stay on topic. When you're drafting your comments, ask yourself, is what I'm saying related? Does it go back to asking them to do something or not do something, to having an ask, being clear and staying on point? That's, if you remember nothing else from this today, remember those things. Be clear, ask them for something. Keep it concise. Stay on point. Now, we have entered our comments at the Treatment Advocacy Center. We have submitted our comments. I'll be concise with you all right now and tell you that our comments are only a couple of pages, but they got into the weeds of discussing and what should the privacy rule really do, and what is it doing, and will these proposed changes help? If any of you all want to see those comments, we can send them to you. We of course voiced our support for those two changes, the changes in language, the good faith belief that sharing information is in the patient's best interest, or to prevent a reasonably and foreseeable threat of harm. And then in our comments, we also responded to some specific questions that OCR asked in their great big notice of proposed rulemaking document, their 90-some page document. They had a few points they wanted specific feedback, and we gave them that on anything that pertains to our work and our policies and positions on this issue. However, we could not submit comments without letting OCR know, without letting the federal government know that if you're really going to amend the privacy rule, go as far as you can. Of course, we don't want inappropriate invasions of someone's privacy, but there's nothing inappropriate about sharing information relevant to treatment of SMI to help someone who's in a psychiatric crisis. In fact, you could argue that's a clinician's obligation. That if you have information that will facilitate a conversation with family that leads to better and more effective treatment, and it's not prevented, sharing that information is not prevented by the privacy rule or by your state laws, not sharing that information, not having that communication is doing harm of its own. And as always, I have to encourage OCR and the federal government to be clear when they give guidance to providers, what is and what is not a violation, because there's so much confusion about that. There are highly intelligent attorneys who study this stuff and doctors who deal with it every day who still don't quite grasp that. And that's, the government could do more, educate. And last, but absolutely not least, in fact, last and as important as anything else, in tax comments to OCR, we encourage them to continue listening to families and people impacted by SMI. That is all I have in this presentation. I know we have some questions, and I'm going to, let's see if I can get this right this time and stop sharing my screen. Nope, that's not what I want to do. Why am I suddenly so technologically ill-inclined? There we go, stop share. All right.
Thanks, Michael. It was really great. So we've had a few questions during this. If you have any questions just go ahead and send them in the chat to the panelists, and we will get through as many as we can. So our first question was from Susan. She said, when a family member provides information to a physician about their loved one, is that information legally to be kept confidential, or is that the physician's discretion?
You mean confidential? Let me make sure I understand the question. Yeah, anything in the course of treatment is always presumed to be confidential, unless, I'm trying to think. I mean, in normal case of treatment, I'm sorry, we're getting all befuddled. I want to make sure I get this question right.
I can read it again if need be.
Yeah, well, no, I've got it here. So make sure. Do you mean like share with other people treating the patient, so other hospital faculty and staff? Because if that's the case, then I mean it's
confidential
like,
to the patient.
Oh, meaning can the doctor then tell the patient, you know what? I'm going to do the thing I don't do very often and tell you I don't know how the privacy rule treats that, but I'll find out, Susan, and I'll get back to you. Susan, can you drop your email in there? Really appreciate that, because if you mean, if I think what you're asking is, can the physician then tell the patient, let's say the patient is not lucid at the moment of the sharing, but then say, oh, your mother or your father told me something about, about your PHI. That is tricky, and it would be case specific, but let me come over the privacy rule and get back to you. Great question, Susan.
So Janet asked, diabetes is not an imminent threat either. It's a reasonable and foreseeable threat to death. Would mentioning parity help?
Yes, let's talk about parity for a moment. And it's one of those things, again, where most of you on here know what we mean by parity, but talking about treating the laws and regulations of mental health the same as physical, anything else. And diabetes is a good example. The thing about the privacy rule is that although these specific changes, I mean, these changes are, OCR has been clear, these changes are about helping families like a lot of you all who have a loved one with SMI. I mean, they've been pretty on point about that. Privacy rule applies to any type of healthcare situation. And so when OCR hopefully makes these changes, these proposed changes, it would apply to just about anything. There's just as a quick example, the most obvious example to me of when a physician needs to disclose something to prevent an imminent threat, and could certainly be doing a lot more of it under the reasonable and foreseeable definition, is when someone goes to a doctor, either a PCP or an eye doctor, and their vision is so bad, there's no way they could possibly operate a vehicle. Doctor asked them, well, you're not driving anymore, right? And they say, oh no, I drove here today. And doctor says, you can't drive home. And they said, you can't stop me. This is a conversation that happens all the time with primary care providers, optometrists, and ophthalmologists. And those doctors very often disclose the information that someone's vision is so bad they can't safely drive. And I know that doesn't sound related to SMI, but the privacy rule applies. Those doctors have to make right now an exercise of professional judgment that there's a serious and imminent threat. So that's how they're related, is that privacy rule covers everything. It's not just about mental illness. It's just what we're talking about today is SMI. And these changes are about, they're to correct a problem with SMI, but I spoke with an optometrist about this yesterday and was told, like, yeah, this would actually be great for them too. It's not as common a life and death thing as it is for physicians treating someone in psychiatric crisis, but it's still life or death. So that's a little bit on parity and the fact that in theory, HIPAA does not discriminate mental health versus physical health, but just like everything else in the American healthcare system, of course, there's a difference, of course, unfortunately. And hopefully this will address some of these changes, will address some of that.
So we had somebody ask, I've heard that educational institutions can share your records and have different standards than HIPAA. Can you explain that?
So I'll give you the short version, and I will encourage you to shoot me an email and follow up with me on this, because the short version is that there are some exceptions contained within the privacy rule that pertain specifically to educational institutions. And there are situations in which an educational institution could be considered what the privacy rule calls a business associate, meaning an entity that is not a covered entity per se. One of those, remember, covered entities are health plans, clearinghouses, healthcare providers. They're not necessarily a covered entity, but they do enough business with and interactions with covered entities that they have to use some of that PHI. And there are times when an educational institution could be considered one of those and could be subject to the privacy rule. That's the short answer. By all means, please shoot me an email. If you can't tell, I'm having to be concise. I'm having to keep myself on a leash here to keep from rambling about this for a while, but it's a great question.
We'll also give Michael's email at the end in case there are any questions that we don't get to, or you want to follow up with him as well.
Yeah, and one of our colleagues, Amy Lukes, just said they're probably asking about FERPA. That's true, probably are, which is all the more reason. So I went down the HIPAA education institution alley, but yeah, they probably are, Amy, which is something else I'd love to follow up with offline. So please, yeah, when Emily drops my email at the end, please shoot me an email, because I'd love to talk about FERPA some too. And that's one of those things where if I don't have the answers on that, some of my colleagues certainly will. So please follow up with me, and I'd love to talk about that a little more.
So we had Mary ask, why is behavioral health care allowed to implement HIPAA laws differently than physical health care, especially when it comes to requiring consent on the patient's part to talk to family when they are acutely ill?
So this is one of those issues where, as I was saying before about parity, in theory, privacy rule and all of HIPAA should apply to SMI situations, just like any other type of healthcare situation. But in practice, it doesn't work that way. That is, to speak very generally, that is often one of the cases, a case where healthcare providers don't understand how the privacy rule applies to SMI, to patients in psychiatric crisis, because there are certainly situations where an emergency room provider would disclose information to someone who'd been in an auto accident who's now in a coma when their family comes in and seeks information, or when the family just calls the hospital and has questions about their status and where they are and how the treatment is going. That's one thing, but then that same provider may not disclose if it were a psychiatric situation. That's a problem, but I will say this: the misunderstandings of the scope of HIPAA are so broad among healthcare providers. There have been cases where what you're describing for patient's consent, and that for when someone can't possibly give consent, has happened with physical situations. There was a large plane that went down in the Pacific, somewhere near San Francisco a couple of years ago, and the hospital would not give information to families who were just trying to find out if their loved one had survived the crash and was in their hospital or not. That's not a mental health situation, and yet providers did not understand they could disclose that, and that's that they could disclose the information. Yes, they're here, they're in surgery, they're in a coma, whatever. And so it sometimes does apply across the board, unfortunately.
We have another question from Susan. What can be done so that physicians feel less of a threat of liability when deciding to address the family? Is it possible for there to be language in a proposed change that would lessen their concern of liability?
Absolutely. And I left, in the interest of time, I don't believe I didn't touch on this a few minutes ago when I had my slides up, but on the Treatment Advocacy Center's comments we submitted, we actually encouraged OCR to to provide some insulation, for any covered entity, but particularly providers, if they're concerned of being sued or concerned of getting another issue. I should say they're often concerned of getting fined. The one thing the government can do is fine people for violations, fine them quite a bit, up to 1.5 million a year for violations of HIPAA, of privacy rules. So yes, they should, and that's something I know the late DJ Jaffe, may he rest in peace. That was one of the points that Healy drove home a lot, as have treatment advocacy center staff over the years, about the fact that there should be some way to insulate, to make it clear to providers they are insulated if they are providing information that's permissible to share and it's going to save someone's life.
If anybody has any specific state specific questions, please feel free to email Michael after, so that he can find a little more information on it before we get back to you with a quick response. Ralph asked, why not require a provider? You guys are asking a lot of questions. Why not require a provider to disclose information to a parent when a person being evaluated is not rational or believed to have SMI? Provide the same disclosure to the patient upon discharge.
So you're saying that, I think the question is that there's situations where the providers give information to the patient upon discharge, but at the time that there needs to be a sharing of information to facilitate better treatment, they won't share that with the family. And that's ask why. The answer is twofold. One, it's what we've been talking about today. Number one, providers misunderstanding the privacy rule and what it does and doesn't say, and what it doesn't restrict them from doing. And number two, even if they do understand it and are trying to follow it and trying to disclose information that's needed and trying to communicate with families, then the current standard for what's allowable and when that's allowable is too high. The standard, it's a bar that's too high for them to jump over sometimes.
Linda asked, what is the data on providers being sued or fined? Is that common in SMI cases?
I don't have, and we can find out if Treatment Advocacy Center has some data. I don't have data as far as the SMI cases. I can tell you generally, I have seen what data is out there on just generally across the board. Being sued, again, there's no private cause of action under HIPAA, meaning HIPAA does not give someone the opportunity to sue a provider just because they disclosed information. However, the provider can be sued by the patient under state law. And that's a problem, and that's what really scares a lot of providers. And then as far as the fines go, the answer to that is also a little complicated, because yes, OCR fines providers, but the last numbers I saw, which at this point are 3 years old, I think, but still, they're still relevant numbers. There's a backlog. I mean, there's so many complaints, and very few of those end up fully resolved in any way that you'd be able to recognize under the privacy rule and under the HIPAA, the intent of HIPAA. But yes, and they can be fined quite a bit. You can be fined between $100,000 to $50,000 per violation, depending on the type of violation. And when I say violation, that can be like one piece of information that's shared about one patient. That's a violation, up to 50 grand. So those add up, and those do scare providers. But so when someone's in psychiatric crisis, so much of the time that providers think, they think they're going to get fined or get sued, they absolutely would not be, because they're not violating any law. They're afraid they might be violating a law, so they err on the side of caution. But in the case of psychiatric crisis, that means putting someone's life at risk.
We're getting a lot of questions of if this will be shared later. I should have said that at the beginning. Yes, this is being recorded, so you will be able to access it later. We'll upload it to our YouTube channel and share it out on our social media platforms as well. We had somebody ask, how can providers be held accountable for harm or death caused by misapplying HIPAA law, refusing to receive information from family?
That's a great question. And this is one of those things where I should see if some of my colleagues know. I don't know. I don't know if there's been any litigation to that degree. I doubt there's a cause of action there, but there are certainly, I mean, there are certainly, unfortunately, liability cases for wrongful death when providers have not done all they could legally and ethically do to provide proper care for someone who then either passes away in the hospital or more often is released and passes away because of their mental illness. I wish it didn't have to come to that, but let's dig into that a little bit. That's something I want to know more about. So if that person as well, when Emily puts my email up here in a couple minutes, please send me an email. This is we're trying to get to all these questions, but if we don't get to yours, do not hesitate to email me. If you can't tell, I wish I had. I want to be respectful of your time, everyone, but I wish we had more time to really get into these, because especially the ones where I don't know the answer, because I want to find out and I want to talk to y'all about that some more. We can learn a lot about how to keep these tragic situations from happening if we learn more about what's going on with the privacy rule right now.
So we had somebody ask, I experienced a situation where my son had signed a release that their information could be shared with me, but the provider refused to share information with me. Does the proposed reg address that, and how?
It does not address that specifically. This is one of those things where I said we can't give legal advice, but I would love, if I'm not a practicing attorney, if I were your attorney, I'd like to know a lot more details about that. But that's because there are situations where a doctor must obey certain directives and so forth. So, but that's all I'll say about that without getting into the murkiness of that. Although it's so important, and this would not address that directly, but wow, what an important issue. But that might just be a provider acting inappropriately. I said might, but it's what it sounds like.
Somebody asked, can we acquire a list from you for many of the HIPAA misuses and where the law is written so we can encourage treatment providers to help families?
Yeah, so a couple things there. Where the law is written, yes, we would be. I had it just. It wasn't even. You couldn't get the link anyway, but it was. I had the citation on my slides, but we can absolutely send that out. I don't want to put you on the spot, Emily. We can send an email to all participants, right?
Yes, I think we can.
Awesome. If we can do that, then yeah, we can send. I'll put together a list of some basic links, not just the proposed changes, but also current privacy rule. HIPAA statute. I mean, it's all there if you want to read it. HIPAA statute. I don't recommend it unless you really want to read that. But the privacy rule, though, the parts that pertain what we're dealing with today, these proposed changes, I recommend reading the existing one and then the proposed changes, and we can say in our email, like, this is, these pages are the ones that we're concerned with, that we're talking about, that impacts family members. So yeah, and as far as violations, I know there is some literature out there, but it's not pointed from this perspective. There's literature about educating providers, and it's all over the map. A lot of it is fear mongering for providers, basically, but not all of it. Some of it's good stuff. But we don't have anything directly on that to send you, but I'll keep an eye out, because it's worth thinking about. There should be much better education around this for mental health providers, for sure.
So I'm going to tie this up. Thank you, Michael, so much for sharing this with us today and doing a great job on your webinar. Just want to remind everybody that our next webinar in this series will be a town hall with our acting executive director, Lisa Daly, on March 17th at 12 p.m. Eastern Standard Time. And if you have any questions for Michael, his email is graym@treatmentadvocacycenter.org, graym@treatmentadvocacycenter.org. And as I said, this is being recorded, and so we will share it later. So yeah, thank you all so much for joining us today and for your great questions.
Yes, thank everyone so much for joining us. Please email me. We didn't get to your question, or if we had someone you hadn't thought of yet, send it my way. Please do. And thank you all so much. And thank you, Emily, for making this happen.
Thank you,
all
Mike.
for being here.
Okay, everybody have a great day.